Mr. Kirsnow.
One question. You may have seen, if you were here in the video, that police that arrived on the scene, apparently they declined to either remove the individuals from the polling place or to arrest them. Is that in any respect relevant to the decision of DOJ not to file or not to pursue default judgment in a civil action for 11B?
I don't think so, because the police, the local police would not have been charged with enforcing this federal statute, and whatever state and local laws they were enforcing would have raised separate issues.
Thank you. No further questions, Mr. Chairman.
Commissioner Taylor?
None.
Commissioner Yockey?
Yes. Next question, round two. Mr. Davis, you were, again, at the Justice Department a very long time. I'm wondering if you're at liberty to comment on Attorney General Casey's referral to OPR of the U.S. Attorney and Civil Rights Division politicization issues.
I'm just not familiar with those issues. I didn't work on them in the department, so I don't.
You're unfamiliar with the findings of the report?
I'm generally familiar. I had no official capacity involved.
Would it have, well, let me ask you this question. Given the findings regarding the report that there was a substantial politicization in the hiring and assignment of attorneys within the Civil Rights Division of the Justice Department during a certain portion of the Bush administration, does that not give you some pause as to whether or not the incoming administration had a right to review decisions made by the previous Civil Rights Division?
Well, they had a right, I guess. I mean, I start with the case, and I see what seems to be, on the face of it, a strong complaint. We've heard here evidence that tends to corroborate the allegations in the complaint. I would think that the Justice Department had at least some of that evidence in its files.
Well, let me ask
So,
you, but let me ask you this. To me, the evidence that has been presented today, such as it is, I mean, someone said we weren't relitigating this, and I tend to disagree because that's exactly what we've been doing all day today. Goes, I think, very strongly against Mr. Shabazz. Mr. Jackson, I'm not prepared to make a comment one or another, but clearly, in terms of some of the conduct and statements, Mr. Shabazz was out there. But this case was not simply about Mr. Shabazz and Mr. Jackson. It was also about a national organization. It was also about a national defendant based in another city. So my question, really, I mean, are you telling me that if you went into a department that a neutral body, OPR, had said was rife with politicization, that hires and assignments have been made based on political loyalty, your willingness to be on their team or not with regard to your political and ideological viewpoints, that it would not cross your mind perhaps to take a look at some of the decisions that they had made if you were incoming, whether it's, forget if it's left or right, just say you're the new guy coming in, Assistant Attorney General Kansas, into a situation where you know this department has had an OPR review that goes, things were not going on very well in this department. Decisions were being made that had nothing to do with merit, had nothing to do with the integrity of the division. You're saying to me it would still be hands off entirely on this case or any other case?
No, I mean, look, it's never hands off entirely. In terms of the significance of the OPR report with respect to this case, I would think they're there may be,
He's making.
now he's after me.
He's making his rounds.
Look, if OPR reached an adverse conclusion about the competence or integrity of the specific lawyers on that case, maybe it would have relevance and counsel the kind of fresh look you're suggesting. To my knowledge, OPR did not make such findings. So if you're suggesting that based on either generalized concerns about politicization or findings about other employees in the department, would that strongly support a de novo consideration of this issue? I think the answer to that question is no.
Yeah, I'll follow up. My time is up.
Okay, Commissioner Melendez? All right, that was our second round.
No?
No, we still, you keep on missing those guys.
Please don't take it personally. I apologize. Commissioner Harris?
Okay, because I am going to pass anyway. I do, however, just want to clarify the record. There's going to be stray statements about some creature. There's a housefly that is circling around and is overly friendly. So anyone reading this transcript in the future will understand that.
Okay.
It is a large housefly. It is a 747 of housefly.
Thank you for that clarification. Commissioner Graziano?
Yeah, this may help pick up the line of questioning I was on. It seems to me that, you know, American people's or any citizens of any nation's respect for the rule of law has to be cultivated by a long train of proper enforcement of the law by public officials. But would you agree with me that it could be undermined more rapidly by perhaps even a single wrongful but notorious action?
Sure.
So so individual actions that are open, notorious, well known have a greater impact. The implications of them are broader than, you know, even a train of rightful conduct.
Other things equal, yeah.
Yes, okay. So is it worse, if you think the suit should not have been dismissed, and that's been your written and oral testimony, is it worse for the government to have said, well, these were 11B violations by all 4 defendants, but we just don't want to spend any more money on them, and it's cheaper if we just get a judgment against the most flagrant of them? Or is it worse for them to maintain to the public and to the commission and to members of Congress that no, those 3 other defendants did not violate 11B. We could not. It was improper to maintain a case against them.
I think the latter position is untenable.
And why is that?
For the reasons I've said. I mean, you saw the videotape. The 2 defendants at the scene in Philadelphia were acting in concert, wearing military uniforms, stationed right in front of the entrance, within arm's length of people who had to enter, hurling racial insults at people, and one of the 2 had a weapon. That seems like a pretty clear case.
So
And as to the National Party, some of the videotape evidence that you presented suggests that these defendants were acting pursuant to the National Party and consistent with its broader agenda of racial antagonism.